Jamnagar Petrol. Reliance Industries Limited had filed a GI application for its Krishna Godavari gas and Jamnagar petrol, diesel and LPG. The application sought authorized usage of the name Jamnagar LPG, oil, petrol and diesel, though later the application was abandoned by Reliance, but the specification and the rationale behind its acceptance are worth wondering at. Section 11(2) of the GI Act mandates an application to contain a statement that proves or establishes the GI to designate the goods as originating from the concerned region in respect of specific quality, reputation and other characteristics of which are due exclusively or essentially to the geographical environment with its inherent natural and human factors. Under specification, RIL stated that the ISO standards met by its petrol, fuel, LPG and diesel. There was no mention of any unique properties possessed by the goods. There was no mention of any unique properties possessed by the goods in the application by RIL except the compliance with ISO standards. Under the column Proof of Origin, Historical Records, Reliance stated as follows. In 1991, the Government of India allowed the investments from the private sector in this field. Heavy investment has been made in the less favored remote area, which has resulted in the improvement of local rural area and paved way for the retention of the rural population in this area, and it helps in the rural development. The applicant, in a record time of 15 days after the historic heavy cyclonic hit on 8 June 1998, repaired the extensive damage and brought back the normalcy. The whole matter was dubious, and the surprising fact was how the registry had allowed such a publication. The controversy was more or less ended after Reliance abandoned the application. Basmati rice. On 2nd September 1997, the US had granted patent number 5663484 to Ricetech Incorporation, a US multinational company, for new lines and grains in the name of Basmati rice. This was objected to by two Indian non-governmental organizations, Center for Food Safety, an international NGO that campaigns against biopiracy, and the Research Foundation for Science, Technology and Ecology, an Indian environmental NGO who filed legal petitions in the United States. The Center for Scientific and Industrial Research also objected to it. They sought trade protection for Basmati rice of the Indian subcontinent and jasmine rice of Thailand. They demanded amendment of US rice standards to specify that the term Basmati can be used only for rice grown in India and Pakistan, and jasmine for the Thai rice. The Indian government, after putting together the evidence, officially challenged the patent in June 2000. The contention of Ricetech was that Basmati is not a name of a geographical area, and hence it is not qualified for protection under the TRIPS agreement. However, when it was proved that though the name Basmati is not the name of a geographical area, but still it is inextricably linked to its region of origin, that is India, Ricetech contended that Basmati is a generic name and has fallen into the public domain. In 2000, after years of litigation and hearing, the USPTO granted patent only to a few varieties instead of the sweeping claim of new lines and grains. But the event was an eye-opener for India, and it was in this backdrop that the GI Act of India was passed in 1999. Darjeeling Tea. Tea Board, a statutory authority of the Government of India established in 1953 under the Tea Act 1953 for the purpose of controlling Indian tea industry, owns the GI for Darjeeling tea, which is the tea grown in 87 gardens in the district of Darjeeling. The tea board has fought more than 15 cases against infringement and misuse of Darjeeling in the last 4 years, including Sri Lanka, where the importer agreed to abide by the regulations. This is an effort that stems beyond areas where Darjeeling tea is exported. Republic of Tea, USA, 2000 to 2006. Tea Board was successful in seeking rejection of trademark application for Darjeeling Nouveau in the name of Republic of Tea on the basis of its geographical certification marks for Darjeeling word and logo. The opposition had been filed by the Tea Board before the Trademark Trial and Appeal Board, which has not only upheld Tea Board's opposition but also denied Republic of Tea's counterclaim for cancellation of the Darjeeling certification mark on grounds of genericness. The Trademark Trial and Appeal Board held that Republic of Tea had not proved that consumers view Darjeeling tea as a generic type as opposed to tea from the Darjeeling region of India. It also recognized Tea Board's continuing efforts to maintain control of the mark and protect its value as a geographic indication. The Trademark Trial and Appeal Board held that regulations and licensing program put in place by the Tea Board constitute adequate provisions for control. It also placed great stock in the Tea Board's ongoing efforts to educate the public, example by attending trade shows and distributing literature in supermarkets as further evidence of the Tea Board's overall system of controlling consumer understanding. Dusong, Darjeeling with kettle device for stationery, France. The Court of Appeal of Paris on November 22, 2006 quashed the decision of the Court of First Instance rendered in August 2005, wherein the action filed by the Tea Board for dilution of Darjeeling against adoption of the mark Darjeeling with a kettle device in respect of classes 16, 35 and 41 by Mr. Dusong. In its decision, the Court of Appeal Paris held that Mr. Dusong's mark impairs the geographical indication Darjeeling and is prejudicial to the Tea Board's interests in the same. Accordingly, the impugned mark was nullified. Mr. Dusong has been restrained from using the same in any connection whatsoever. Further, the court has imposed a fine of Euros 500 for each breach that would occur after 1 month of notification of the decision. Mr. Dusong was to publish at his expense, but within a total of Euros 5,000, the decision in 3 newspapers, either French or foreign, of Tea Board's choice. Mr. Dusong was also sentenced by the court to pay an amount of Euros 2,000 to the Tea Board. Other cases. Other marks opposed including Divine Darjeeling, Darjeeling, Darjeeling Nouveau, relating to diverse goods and services such as clothing, lingerie, telecommunication and internet services, coffee, cocoa, etc. Further used by BVLGARI Switzerland of the legend Darjeeling tea fragrance for men was agreed to be withdrawn pursuant to legal notice and notifications. To conclude, I would like to discuss the EU-India FTA. The Free Trade Agreement, or FTA, was to be entered into by the European Commission to regulate issues such as competition policy, the rights of foreign investors, open government purchasing practices, as well as environmental, social and human rights clauses. However, sharp differences arose with respect to intellectual property rights, competition, agriculture, public procurement, market access and transparency. One relevant example was the concern raised by Amul in 2013. It was feared that further reduction in import duties would enable the EU to dump subsidized products in the Indian market, as EU did not allow import of Indian dairy products, citing its strict sanitary standards, which is suspected to be nothing but a non-tariff barrier. Thank you and a very good afternoon to all of you.